Welcome to this video on Deep Dive into DPDP Act 2023. In this 9th part, we will explore the critical aspects of enforcement, penalties, and grievance handling under the Act. Effective data protection requires a structured approach. This involves resolving complaints internally, understanding the role of the Data Protection Board, and proactively managing risks related to enforcement and potential penalties. The DPDP framework gives data principals access to grievance mechanisms and gives the board authority to investigate, direct remedial measures, and impose penalties. Enforcement is not only about punishment after a breach. A well-designed internal grievance process can identify problems early, correct errors, and prevent escalation. By the end of this video, you will be able to explain the board's role, design internal grievance workflows, identify enforcement powers, understand penalty categories, and build evidence and escalation controls. The objective is to help you understand both the legal structure and the operational response. You should be able to follow a complaint from submission through verification, investigation, resolution, escalation, and closure. You should also understand that a grievance process must be accessible to genuine complainants, while including proportionate safeguards against impersonation, abuse, and false information. Accountability operates at 3 levels: the data principal raising a grievance, the data fiduciary or consent manager investigating, and the data protection board conducting inquiries if necessary, with an eventual appellate route. The first opportunity to resolve a complaint generally sits with the organization. If the issue remains unresolved, or if the matter involves a breach or serious noncompliance, the board may become involved. The model encourages organizations to resolve issues early, but it does not allow an organization to hide or obstruct complaints. An internal mechanism must be genuine, functional, and accessible. To make raising a grievance easy, organizations should provide clear, accessible channels, acknowledge receipt promptly, define ownership of the issue, set resolution timeframes, and communicate escalation paths. The grievance route should be available through the organization's website, application, privacy center, or another readily accessible channel. A user should not have to search through unrelated pages or contact multiple departments before finding the correct route. The rules require the grievance mechanism to explain how a data principal can make a grievance and the period for resolving it. The published timeline cannot exceed 90 days. Correctly capturing a complaint is vital. Ensure you document the complainant's identity, the channel of receipt, the specific issue, relevant references, supporting information, and assess the urgency to assign the right owner. A grievance should receive a unique reference number and acknowledgement. This creates a traceable record and allows the organization to monitor aging, escalation, and closure. The intake process should not be unnecessarily burdensome. Verification should be proportionate to the sensitivity of the information and the action requested. A person should not be denied a legitimate complaint simply because the first message lacks every possible detail. Categorization is key. Identify if the issue involves access requests, correction or erasure, consent notices, security breaches, unauthorized disclosure, marketing preferences, nominee issues, or third-party vendor concerns. Classification determines routing and urgency. For example, a complaint about an incorrect address may go to a data quality workflow, while a complaint about unauthorized disclosure may require immediate privacy and security escalation. A single complaint may involve multiple categories. The organization should avoid closing a grievance simply because one part has been addressed while another part remains unresolved. Protect the process while handling complaints. Verify the complainant appropriately, confirm authority for nominees, avoid unauthorized disclosures, accept only relevant and genuine evidence, and ensure the process remains accessible. Verification is necessary because a grievance may involve access to personal data, correction of sensitive records, or deletion of an account. However, verification should be proportionate and should not be used as a tactic to discourage genuine complaints. The DPDP Act also places duties on data principals, including not impersonating another person, not filing false or frivolous complaints, and providing authentic information when seeking correction or erasure. These duties justify reasonable checks, but do not eliminate the organization's obligation to provide a workable complaint route. Investigations must be fair. Review relevant records, speak to responsible internal teams, check your systems and vendor arrangements, assess legal impacts, decide on corrective actions, and communicate outcomes clearly. A grievance investigation should be evidence-based. The organization should review the original request, notices, consent records, system logs, communications, vendor records, and relevant policies. The response should explain what was reviewed, what action was taken, and what limitations or exceptions apply. A vague response such as, "the matter has been handled," may not adequately demonstrate fairness or accountability. Track the clock. Acknowledge receipts, set internal targets, monitor progress, escalate overdue matters, ensure resolution within the published period, and record any necessary extensions with clear reasoning. The organization should set internal targets that are shorter than the maximum published resolution period. This creates time for investigation, legal review, approval, and communication. A dashboard should identify grievances approaching the deadline, grievances requiring cross-functional input, and grievances that have been reopened. Delayed response is itself a governance risk, especially when the complaint concerns a previous failure. The board may become involved in cases of data principal complaints, personal data breaches, non-compliance by data fiduciaries, violations of rights, failures by consent managers, or specific intermediary matters. The board's role is broader than reviewing monetary penalties. It can examine complaints and breaches, seek information, require cooperation, direct remedial action, and impose penalties where appropriate. Exhausting the internal grievance mechanism is generally required before a data principal approaches the board, but this does not allow an organization to delay or frustrate the internal process. The board holds investigative and remedial powers, including inquiring into breaches, calling for records, directing immediate measures, issuing binding orders, imposing monetary penalties, and managing representations. The board's powers are intended to support both fact-finding and harm reduction. In a serious breach, the board may direct urgent mitigation, rather than waiting until the entire inquiry has concluded. Organizations should therefore treat a board inquiry as a formal legal and governance matter. A response should be coordinated, accurate, complete, and supported by preserved evidence. Understand your exposure. Failure to maintain security safeguards can lead to penalties up to 250 crore, while other breaches or failures regarding data principal duties carry their own defined financial limits. The Act's schedule establishes different maximum amounts for different categories of breach. The highest cited category is failure to take reasonable security safeguards to prevent a personal data breach, for which the maximum can reach 250 crore rupees. A statutory maximum is not the same as an automatic penalty. The board considers the nature, gravity, and duration of the breach, and other factors prescribed under the Act before determining the amount. Penalties are assessed based on conduct. The board considers the seriousness of noncompliance, failure to cooperate, systemic weaknesses, actual harm to individuals, and the adequacy of documentation and mitigation efforts. Penalty analysis is not only about the existence of an incident. The organization's conduct before, during, and after the incident matters. Examples of positive factors may include prompt containment, transparent communication, cooperation, strong pre-existing controls, and documented remediation. Negative factors may include concealment, repeated failures, lack of cooperation, and absence of reasonable safeguards. Finally, remember that the cost of enforcement extends beyond statutory penalties to include operational disruption, audit costs, reputational damage, and management scrutiny. Proactive compliance is your best protection. A monetary penalty is only one component of enforcement exposure. An organization may also need to investigate systems, support affected individuals, redesign processes, replace vendors, conduct additional audits, and report remediation progress. This is why grievance handling should be considered a risk reduction mechanism. Early correction can prevent a small complaint from developing into a large regulatory or reputational event. Decisions made by the Data Protection Board are not final. Any aggrieved person has the right to appeal a board order or direction to the designated appellate tribunal, provided they act within the specified 60-day filing period. The enforcement structure includes an appeal route for parties aggrieved by a board order or direction. The current statutory route identified in the available board guidance is the Telecom Dispute Settlement and Appellate Tribunal, commonly referred to as TDSAT, with appeals generally filed within 60 days. This information is intended to provide structural awareness, not legal advice on litigation strategy. Organizations should obtain specific legal advice when responding to a board order or direction. Let's consider a scenario. A customer requests an address correction, but the organization takes no action for weeks despite follow-ups. This highlights a clear failure in grievance handling that can trigger regulatory scrutiny. This case combines a data principal request with a grievance handling failure. The organization should examine the original request, identity verification, routing, system records, communications, and any reason for delay. A proper response may require correcting the record, explaining the delay, apologizing where appropriate, recording corrective action, and improving workflow ownership. The organization should also assess whether similar requests may have been delayed. In the case of a security breach, failing to escalate internally because of incomplete vendor investigations leaves an organization exposed. Delayed communication increases both the risk to individuals and the likelihood of regulatory penalties. The organization should begin its own assessment as soon as it becomes aware of a possible breach. It should not wait for a perfect vendor report before containing harm, preserving evidence, and determining notification obligations. The delay may increase risk because the organization failed to escalate promptly and did not provide timely information to affected individuals. The review should also examine whether the vendor contract contained adequate breach notification and cooperation requirements. To effectively manage these situations, build a response map. This involves 5 key steps: defining the scenario, mapping the intake process, assigning clear ownership, establishing response and evidence protocols, and finally, assessing potential legal implications. You should select a scenario, such as delayed correction, unauthorized disclosure, failed erasure, misleading notice, or vendor breach. You should map the complete journey from first complaint through internal resolution and potential board escalation. You should identify what evidence would support the organization's position and what failures could increase enforcement risk. The exercise should end with a remediation plan, rather than only an analysis of what went wrong. For further learning, a detailed guide with practical examples is available on the DPDPA Mentor website. This resource helps teams in building a grievance and enforcement response map under the DPDP Act. This guide is based on the steps provided in the previous slide, and various examples are provided for better understanding and practical usage. Always remember the golden rule of compliance. If it is not recorded, it is difficult to prove. Detailed documentation is your primary defense when demonstrating that your organization acted in good faith during an investigation. Records are essential for demonstrating that a complaint was taken seriously and handled consistently. A grievance register should allow the organization to see open matters, aging, recurring issues, high-risk complaints, and matters involving third parties. Records should be accurate and proportionate. The goal is not to collect unnecessary information about the complainant, but to preserve enough evidence to show what happened, who acted, when they acted, and why the decision was reached. Grievance handling often breaks down due to lack of ownership or inconsistent follow-through. By identifying where these gaps exist in your current workflows, you can proactively strengthen your response and maintain accountability. A grievance process can fail in 2 opposite ways. It may be too weak, allowing genuine complaints to disappear, or too restrictive, making it difficult for data principals to exercise their rights. A mature process balances accessibility, verification, investigation, documentation, and timely resolution. It should also use recurring complaint data to identify systemic problems, rather than treating every complaint as an isolated event. In summary, focus on timely communication, clear documentation, and establishing defined escalation paths. These fundamental practices are essential to complying with the DPDP Act and protecting your organization from unnecessary risk. Remember that enforcement readiness begins with everyday process discipline. A visible grievance channel, clear ownership, proper records, timely responses, and effective remediation reduce both user harm and regulatory risk. The strongest organizations do not treat complaints as threats. They use them as signals that reveal weaknesses in consent, security, data quality, rights handling, vendor oversight, or governance. If you are interested in trying out the DPDP Act provisions, you can use the Consent Manager Simulation portal at myconsentmanager.co.in to test your integrations as a data fiduciary or data principal. We recommend the CalPI Quiz app, available on the Google Play Store, to test your knowledge of cybersecurity, the DPDP Act, and other important topics. The app offers various levels of difficulty and interactive assessments to improve your awareness. Thank you for watching this video relating to Deep Dive into DPDP Act 2023. Hope you now know more about enforcement, penalties, and grievance handling under the Act. This was the 51st video in this series released by DPDPAmentor.in. Please visit our YouTube channel, DPDPA Mentor, as well as our website, DPDPAmentor.in, regularly to check out other informative resources. Wishing you a successful DPDP Act implementation.